Good morning. Good morning, everybody. Looks like I'm having feedback. All good now? Okay. Good morning, everyone. Noting the time, it is just after 9 in the morning on January 15th of 2026. My name is Albert Chang. I'm the chair of the Oil Conservation Commission, and I'd like to call this meeting to order. Commission Clerk, could we please have a roll call of the commissioners?
Yes, Commission Chair Chang,
Present.
Commissioner Ampoma,
Present.
Commissioner Bloom.
Present.
Great. With all commissioners present, we have a quorum. I'd like to proceed to our second item on the preliminary agenda, which is approval of today's agenda. Is there any discussion on that from anyone?
No, Mr. Chair, I would move to approve the agenda.
I'll just make one quick note and then I'll entertain that motion. I'll make one quick note that I know there is significant interest in the last item on the agenda for the hearing on whether to hold a public hearing on the proposed rules for 1915-41, 1915-42, and 1915-43. For everybody's scheduling purposes, my plan is to break for lunch right before that agenda item. So since it's hard to control the timing of all these cases, so that we start fresh on that case at 1 p.m. after lunch. With that note, we have a motion on the floor to adopt the agenda. Is there a second?
I second.
Any objections? Without objection, so approved. I'll turn to item number 3, which is approval of the meeting minutes for OCC meetings on November 13th, 2025 and December 17th of 2025. Are there any edits or comments, concerns?
Mr. Chair, I had no edits or concerns. They look good to me. Thank you, Sheila.
I do not have any concerns on that. Thank you.
In that case, I'll entertain a motion.
I would move to approve the minutes.
I second.
Any objection? Without objection, so approved. Moving on to the 4th item on the agenda. We're just zipping through it today. I had sent for the record, for everybody else, I had sent a letter to the other commissioners yesterday, and I'm just going to discuss that on the record now, so it's also public. As you probably have seen in your emails, I would like to propose the idea and get the commission's blessing to offer and to encourage parties in adjudication cases in front of the commission to participate in pre-hearing mediation. Voluntary mediation is a confidential process in front of a neutral third-party mediator to help parties communicate and negotiate to find mutually acceptable solutions in disputes. The idea is to use mediation to encourage early dispute resolution, resolve any misunderstandings, clarify issues, narrow the scopes of disputes, facilitate exchange of information, and potentially, hopefully, streamline cases. If parties are able to reach settlement because we have encouraged mediation, great. If not, the idea is that hopefully a mediator or a neutral third-party facilitator can at least clarify what the dispute is about so that when it does come to commission, if the mediation is not 100% successful, the commission hopefully will be able to, hopefully the parties will be able to present a more clarified and narrowed set of disputes and decision points for the commission to decide. So, and I'll quickly go through just a few points here. I'm not going to read the whole thing into the record here, but there is the state of New Mexico does have a Governmental Dispute Prevention and Resolution Act that explicitly authorizes state agencies to use alternative dispute resolution mechanisms such as mediation. That act, along with the Mediation Procedures Act, also provides statutory confidentiality protections for mediation communications that explicitly exempts mediation discussions from disclosure under the Inspection of Public Records Act. So I just wanted to get the commission's blessing of potentially introducing mediation as a concept as sort of the conceptual level at this point. in the future, I think one of the ways that we might be able to encourage parties to participate in mediation, or let me back up for 1 second. Typically, parties involved in disputes typically split the mediator's fees. However, one of the ways that we might potentially be able to encourage that is to use the fee fund or the hearings fund created under the Oil and Gas Act, which collects oil and gas industry permitting fees and can be used for hearing administration costs. So if there is interest from the commission in potentially sort of nudging parties towards participating in mediation, I'm going to look into whether or not the commission could use that hearings fund to potentially even pay the neutrals or mediators fees. So at this point, I just thought I'd invite any comment from commissioners and see if there's any concerns or thoughts on the concept.
Let me go fast. So, Mr. Chair, I read through this. My first impression is that this is a great idea. I do have a couple of questions, if I may.
Please.
So the first question that I do have is, who will initiate this mediation process?
I think the concept is that the parties can certainly ask for it, and we can certainly put that into a pre-hearing schedule, pre-hearing order of some sort at the party's request. We can also offer it as an option. So either way, that can work, right? I think this Dispute Prevention and Resolution Act says that the agency shall provide interested parties with access to alternative dispute resolution procedures. So it's merely an option that we can offer. And at this point, what I'm proposing is voluntary mediation. So it would be up to the parties whether or not they're willing to participate in such a process.
And is there any limit as to the scope, especially, for instance, let's say, will this apply to rulemaking, some portions of rulemaking, or is this going to be contested cases?
At this point, I just wanted conceptual buy-in, and certainly I think we'd want to test this out as a pilot in relatively contained adjudicatory disputes. I think I would limit it to just that, at least for now. And if there really is interest in expanding it later, I'm certainly open to that. But I would limit it to just adjudications for now.
Thank you, Mr. Chair. I do not have any further questions.
Commissioner Bloom, any questions or concerns?
No, Mr. Chair, I like this idea, and I believe we should move ahead with it and see how it works for us and the parties that come in front of the OCC. And I appreciate you thinking about the cost of it and potentially using some funds that are available. So I think it's well thought out, and we should give it a try. Thank you.
Awesome. Well, thank you all very much. I appreciate the votes of confidence. I promise I didn't pay any of them to say that. Okay, well, with that, I'm going to turn to the cases. Just giving me one moment to reorganize my files up here. Agenda item number 5, case, our first case in front of us, I'm going to call case number 25603, which is a status conference on the application by Matador Production Company for de novo hearing on division orders number R23869 and division case number 25283-84, 25283 and 25284. I'll entertain the appearances of counsel.
Good morning, Chair Chang. Adam Rankin with the applicant in this case, Matador Production Company, with the Santa Fe Office of Holland and Hart.
Good morning, Mr. Chair, Commissioners, Dana Hardy and Jackie McLean with Hardy McLean on behalf of Permian Resources.
Thank you all very much.
Mr. Chair, apologies, Matthias Sayer on behalf of EOG Resources.
Thank you. Any other appearances? All right, thank you very much. I will, I'll turn to the applicant first. If you could let us know where you're at.
Good morning, Mr. Chair, Commissioners. Thank you very much. Since our last status conference in December, at the direction of Commission, we have continued to engage in discussions as we prepare for hearing. Parties have been discussing, and I believe we're close to reaching agreement, but nevertheless, we will be prepared for hearing on the 12th if the parties are unable to reach an agreement. So I've conferred with Ms. Hardy, and we agree that we'll be filing our pre-hearing statement and the pre-filed testimony 1 week in advance that we previously discussed of the February 12th hearing date. We'll let you know, of course, as soon as possible if the parties happen to reach an agreement in advance. I know that from my perspective, I think there's some hope that that will be the case, but nevertheless, we'll be ready to move forward if it doesn't happen. I'll pass it off to Ms. Hardy to give her side of the story. Thank you.
Thank you. No, I agree with Mr. Rankin. I think the parties are in discussions, but at this point, we would still like to keep our February 12th hearing date and agree to file our pre-hearing statements, testimony, and exhibits the week prior.
February happens to be a challenging month for the entirety of commission anyway, because it's well, at least 2 out of the 3 of us, because it is the legislative session. So if the parties want an extension to have more time to negotiate, that would potentially, the commission would be open to that if you guys needed that, I think. And if you're close to an agreement, let me know if this might be one of those cases where you might want a third party neutral to facilitate and maybe just nudge the parties towards a settlement. If you can at least narrow the scope of the hearing so that if you can think about stipulating to the testimony that's already been provided in the record in the underlying case, or narrowing the number of witnesses that need to be presented, narrowing the scope of disputed facts. Certainly the shorter that hearing is, if there is a need for hearing, the more likely it is that the commission will be able to entertain it, again, given the challenges of operating during the legislative session. So, and also, I know that minimum rule requirements is only a week, but it's certainly, again, with the challenges of being legislative session, if this really does seem like this has to go to hearing, I think most commissioners would appreciate having a little bit more than a week to be able to review the materials, or at least more than a week, because again, for at least 2 of us, we're going to have a lot of competing demands on our time during legislative session. So I'll put it out there. Do the parties have a sense of what, or are the parties ready to maybe put on the record what you think the major sticking points might be, or is that something you'd like to hold off on for now?
I guess I would say it's a little bit difficult without getting into the merits, but I think essentially it's a bit of a as presented below, it's a dispute over how to best develop essentially portion of a section where there's an overlap between the 2 development projects. And so that's kind of the sticking point.
Okay. And so it's going to be a significant factual dispute then?
I think maybe the best way to articulate it, I think it's fair to say we can narrow it to that tract, at least from our perspective. Okay. How best what the ownership interests are there, and how best to evaluate the development on that overlapping contested track. Ms. Hardy may have a slightly different view, but I think all things considered, that's going to be the thrust of the focus of the hearing, I think.
Okay, sounds good. And if it would benefit the parties to have I can hold status conferences on my own as chair in between commission hearings. So if it would help, I'm open to trying to scheduling something in between the hearings if there is if that would be helpful in sort of making sure that we have an organized and orderly and hopefully efficient hearing. So let me know if there's anything further that the parties might need from me on that.
I will, as we check in with our respective clients, I will also reach out to Ms. Hardy to discuss ways to potentially streamline if we do need to go to hearing, including stipulating to the underlying record or factual testimony so that we can pass over some of that and focus on what we think may be the most necessary elements of the contest. And if it's appropriate, we'll reach out to request a status conference to address those or present those options to the commission chair.
I agree.
Thanks so much.
Thank
I
you.
appreciate it. Is there anything further for this particular case before we move on for today?
No, thank you.
Sounds good. In that case, I will move on to case number 24683, which is the WELC application for rulemaking to amend a whole series of NMAC provisions. This is a status conference. It is my understanding that the parties to that rulemaking have been in discussions and have been negotiating over the contents of the rule. And I'd like to, since this is a rulemaking and therefore public policy making process of significant interest to a portion of the public, beyond the parties, I'd like to invite the parties to at least put on the record a little bit about what is happening amongst the parties that maybe the public isn't aware of. With that, I'll turn to the applicant.
Thank you, Mr. Chair, members of the commission. It's nice to see you. I'm Tanis Fox. I'm a lawyer with Western Environmental Law Center, representing applicants in this proceeding. With me today is Morgan O'Grady and Matt Nikiel online. During the hearing, the parties heard the commission's request loud and clear to meet afterwards and negotiate to try to narrow differences and come to some common ground on the rules. Toward that end, applicants, OCD, IPAM, NMOGA, OCC, and EOG began meeting in November, directly after close of the hearing. And we have met twice a week since then, except over the holiday period, for a total of 9 two-hour meetings. And during this time, we have discussed proposed revisions to OCD and applicants' proposed amendments in a lot of detail. We've exchanged proposals and counter proposals. We've exchanged analyses of the parties' positions in an attempt to come to some agreements and to address concerns raised by the commission during the hearing. In applicants' view, all parties have been negotiating in good faith, and we've made substantial progress, which is why we jointly requested an extension to file post-hearing briefs. We appreciate the commission granting that request. As the commission knows, the issues raised by applicants and OCD's proposed amendments are complex, and as a result, negotiations necessarily take some time. While all parties must ultimately obtain client approval for any agreements, the parties, as I stated, have made substantial progress, and negotiations are ongoing and productive. While consensus has not been reached on every issue, the scope of disagreement has narrowed. And I'll walk through very briefly each part to inform the commission and the public where we're at. We have discussed all 5 parts of the commission's rules that we propose for amendments. Beginning with part 5, which is a part that deals with compliance, we have largely completed those negotiations. We have reached some agreements, and we have agreed to disagree on some areas. On part 9, which is a more complicated set of proposals, they govern operator registration and well transfers. We have had discussions on part 9 at length and in detail. We've exchanged a lot of proposed language. Some agreements have been made, and while discussions are ongoing, I believe that those discussions will be concluded promptly. Part 25 deals with the proposed presumptions of no beneficial use and sort of the legal framework about putting inactive wells, either plugging them or putting them in temporary abandonment. That's also a critical provision. Critical provisions are there, and applicants and OCD have proposed pretty wide sweeping amendments, to the current process. And I am very pleased to report that the parties have reached substantial agreement on the framework for placing wells in temporary abandonment, have agreed to disagree on discrete issues in those sections, and are refining language. We are still in discussions on the presumptions of no beneficial use and testing for mechanical integrity. And I believe those negotiations should conclude soon as well. Part 8 governs financial assurance. The parties have agreed on certain changes related to terminology and timing for assessing financial assurance requirements. Our next focus actually will be on financial assurance categories and amounts. As to the definitions in part 2, we have discussed those, and we're going to come back to those at the very end of negotiations after we sort of see what's happened in the substantive provisions. At this point, we foresee continuing negotiations through the first week of February. And we are considering filing a joint stipulation that would set forth the agreements that have been reached so that that's clear for the commission. And while disagreements will remain, there will be things for you to decide. I can assure you of that. We really do believe the negotiations have gone very well. From my perspective, it's very helpful to sit down in that kind of a setting with industry and hear everybody's concerns. It's been just a very good set of negotiations. And, we hope that they will be helpful to the commission at the end of the day. And I think other parties want to weigh in as well, and I'm happy to answer any questions from any of the commissioners.
Thank you so much. I know that it is a ton of work, and I just want to make sure that you know how much the parties the commission appreciates the work that all the parties are putting into that, and that how much we really appreciate everyone coming to the table in good faith and making these negotiations. But let me first turn to, and I'm sure the other commissioners will want to echo me on that, but I'll turn to the other parties and let everybody get their 2 cents in.
I'll jump in here, Mr. Chair. This is Jesse Tremaine for the Oil Conservation Division. I just want to generally echo the comments and what I expect the other party comments to be. We discussed this in detail actually yesterday. Regardless of where we end up on the specific substantive positions, we do believe that there will be a narrowing of contested issues before the commission once you get to deliberation. We will also echo the comments that I can guarantee we will not be able to secure universal consensus, but the time commitment has been, in the division's opinion, appropriate to narrow the scope of that disagreement. I want to underline and highlight the substance and time commitment from all the parties. As the chair has probably observed, I've effectively commandeered the conference room for over half a week of work time so far. And that will continue for another little while. I think that we are on track to, as Ms. Fox indicated, outline areas of consensus and file closings on a narrowed scope of disagreement. And I believe that we are on track to accomplish that by the current deadline.
Thank you so much. Any other, Mr. Suazo, Mr. Cloutier, Ms. Tripp, anyone else?
Sure. Thank you, Mr. Chair. This is Miguel Suazo with Beatty & Wozniak, appearing today on behalf of the New Mexico Oil and Gas Association. I think I'd like to largely echo the statements of Ms. Fox and Mr. Tremaine. Nemoga's appreciated the chance to learn from OCD and from WELC their concerns and kind of their reasoning behind some of these proposals, as well as the opportunity to voice industry's concerns and put forth some recommendations for making the rules, effective, but still easier to comply with than they were as originally proposed. And so I think the time has been well spent. As the other parties mentioned, there's not going to be complete alignment on these proposals, but I think that they will be narrowed, which is what you all have directed us to attempt to achieve. And I think we've done that. And I think, you'll be able to more easily review the reasoning behind why we support and oppose certain provisions once we submit our final closing documents, and hopefully that'll make the commission's job easier. But I would like to thank the parties and the support of NMOGA and their members to give us the opportunity and the time to hopefully work out a better framework for the regulations that have been proposed, and ultimately end up with regulations that are easier to be administered and to comply with.
Thank you very much. I'll turn to Mr. Cloutier. You might be muted, sir.
Thank you, Chair Chang and members of the commission. I likewise singing from the same hymn book as my three counsel before me. I would indicate that I think areas where the parties may be reaching agreement, some of that agreement may be not that the commission should adopt the rule or the commission has the power to adopt the rule, but should the commission conclude it should adopt the rule and that it has the power to, it will eliminate some of the disputes about the implementation and feasibilities of the rule. I do think that the time has been well spent, and it will enable the commission in its deliberation to focus much more on the bigger questions that the parties have raised, and perhaps less of the minutia in the rules. And I do appreciate Ms. Fox and her teams and Mr. Tremaine and Mr. Hall working with us and providing explanations as to what the issues were that they were trying to address, and enable Mr. Suazo and his team and me and my team to attempt to address those concerns and reduce the burden on industry, and especially those in industry who are not part of the problem. So thank you very much.
Thank you very much. Mr. Rankin?
Thank you very much, commissioners and Director Chang. Yes, I just to reiterate, I think the time spent has been very fruitful, narrowing the issues. As Mr. Cloutier mentioned, I think that while we reserve some of our overarching legal issues and concerns, we've been able to focus on some of the more contentious issues and have largely moved the ball. And I think for Oxy's perspective, we're down to identifying some discrete issues that hopefully we can continue to work on and make some substantive agreement up towards. We have all in all made substantial progress on many issues. And so I think commend all the parties for their good faith efforts. And it's been an enjoyable process, actually. So hopefully at the end, whether we reach final complete agreement, the rule will be an improved one at the end of the process. Thank you.
Thank you. Mr. Sayer or any other council want to jump in or anything? Ms. Tripp? No? All right. Well, good. I will turn to the commission then. Any comments from the commission? Any questions or concerns?
Mr. Chair, I would say that this is great news, at least for us, because there were a lot of issues that were at stake. So thanks so much for adhering to the commission's concern and then trying to come to a consensus. Thank you.
Commissioner Bloom?
Mr. Chair, thank you. I would echo Dr. Nampoma's comments there. I really appreciate that the party's been able to make some progress and have took the time to attempt this. It sounds like it's been fruitful. I think we'll have a better rule because of it. So thank you all very much. Please keep at it. Thanks.
Yeah, and I'll just say what reiterate what I already said. Thank you all very much. The fact that I heard the word enjoyable is, I think I just fell out of my chair. But I think that has been a huge shift in tone, and I really appreciate that from everybody, and the willingness. I really do think that when parties come to the table like that, we make better public policy for the entire state, when we can maximize the benefit to the public while minimizing costs to the regulated community, looking for win-win solutions where they exist, understanding, of course, that the commission at the end of the day will have some decisions to make. That's entirely appropriate, but I really, really do appreciate the parties taking so much time and really sort of engaging with each other in good faith. It very much is appreciated, and I know it will lead to a product at the end of the day that will have more buy-in from all the stakeholders and will deliver for the public. So thank you all very, very much again. All right, thank you all, and I will turn next to issuing orders from cases that were argued and deliberated on at the last commission meeting. I will now turn to case number 25700, but I'm going to pause for a moment in case there are counsel who wish to recombobulate or reshuffle papers. All right, case number 25700. This is the application from Lillian Warren Anderson for de novo hearing. The commission has already heard arguments. There was a summary judgment motion that was argued at the last commission meeting. The commission deliberated and provided instructions, broad outline of a decision to commission council. A commission council provided a draft back to the commissioners. I have provided just a few editorial edits beyond what the commission council provided the commissioners. And I thank you to the commissioners for putting up with my very late night emails. At this point, I will open the floor to the commissioners to see if there are any concerns, wording changes, proposed edits with the latest draft that was sent out digitally last evening. Commissioner Mpoma or Commissioner Bloom?
Yeah, Mr. Chair, I had the chance to read through the updated version of the order, and I do not have any additional comments or inputs on that. Thank you.
Commissioner Bloom?
Mr. Chair, thank you for having revised these a bit, and I appreciate all your edits, and I'm very comfortable with these. Thank you very much.
In that case, may I have a motion to approve the orders as drafted, and so that I could approve and issue the orders?
Mr. Chair, I so move.
Mr. Chair, second.
Much appreciated. Is there any objection? Without objection, so ordered. I'm going to sign these and issue them. If the commission will just bear with me for a moment, I'm going to sign the copy right now. I have to stop and think and make sure I didn't put 2025. With that, for the record, for the audio record, the commission has issued an order granting Alpha Energy Partners motion for summary judgment and dismissing the Andersons application for a de novo hearing. I have a hard copy here for anybody in the room who wishes to have it. We will also have a digital copy filed at some point today. Thank you very much. Now I will turn to consolidated cases 25694, 25695, and 25696. The commission similarly, I think, received a draft order also from Commission Council. The deliberations were already held during the last commission meeting. We received the draft back from Commission council. There were some edits, just a few last evening. Has commissioners had a chance to review, and are there any comments or concerns or debate on the proposed order?
Mr. Chair, so I had the chance to review the original version and then also the edited version, and I feel comfortable with it, and I do not have any additional input. Thank you.
Commissioner Bloom?
Mr. Chair, I'm comfortable with your changes again. Thank you very much.
In that case, may I please have a motion to adopt the proposed order?
Mr. Chair, I so move.
Mr. Chair, I second.
Any objections? Without objection, so ordered. The applications are dismissed without prejudice for lack of standing. The applicant is welcome to refile, assuming they can meet other statutory deadlines, if they can demonstrate that they have sufficient property interest to demonstrate standing in this case. All other motions filed by the parties are also denied as moot at this time. I'm going to sign and issue this order, and it will be filed online at some point today. Thank you.
American objected to the order, to the order.
I think the transcript will reflect that there is an objection, and the objection is noted. Unfortunately, the floor is not open, and the record for this case was closed during the last hearing. So the commission has now adopted the order. So thank you. As I mentioned, if the objecting party can resolve the standing issue, they are welcome. They're welcome if they can meet all the other procedural rules to refile once they can demonstrate standing. Thank you.
Can you revise me? What exactly are you referring to as standing? Because Americans sent numerous evidence clearly stating Americans' defense. And I don't believe that even Alpha not having adequate financial assurances is a violation of obligated duties of the commission and the division to be granting imprudent operators orders to drill wells that are going to cause future abandonment wells because they currently have abandoned wells. To be giving orders like that is not only erroneous, but it creates public harm of health.
So the record is not open right now. The floor is not open to redebate this matter. There has already been an order issued, and I encourage anybody interested in this file.
And you're ignoring Americans' motions, and you're holding Alpha superior, completely ignoring Americans.
We're going to have to control the vault. We're going to have to control. Thank you. We're going to have to bring some order to the hearing room here. I encourage any party who is interested in this order to review the order in detail, to read it carefully, and to proceed as the order advises once it is posted, and it will be posted today. With that, I'm going to move on to the next matter, which actually, since we had said that we would reconvene for the rulemaking petition at 1 p.m., I'm going to call a recess now, take an early lunch break, and we'll come back after lunch at 1 p.m. Thank you all very much.